Hello, I'm Laura Tresize, a partner in the disease practice at BLM and a member of the Asbestos subject matter group. As a subject matter group, the issue of immunotherapy continues to give us much to discuss and consider. Treatments are developing apace. We are facing increasing numbers of expert recommendations for dual therapy, which the MAPS-2 study showed to produce a median survival average of 4 months, albeit with greater side effects. This combination therapy has been approved by the US Food and Drug Administration in October 2020. It remains to be seen whether NICE will have the desire or the funds to follow suit. Based on encouraging data from the 2020 RAIN study, we can also expect to see claims for second-line chemotherapy being combined with anti-angiogenic drugs. In August 2020, as a direct consequence of the pandemic, NICE authorised the use of nivolumab immunotherapy as a second-line therapy following a failed response to chemotherapy. That directive was an attempt to limit hospitalisations caused by the side effects of chemotherapy at a time when COVID admissions were increasing. It remains to be seen whether there will be any reversal of that decision. The raft of new immunotherapy drugs currently under trial and rapid developments in precision treatment continue to require careful monitoring. It is, of course, too early to be making any accurate assessments of the impact of the pandemic on asbestos claims. Certainly, the decision to offer funded immunotherapy in place of traditional chemotherapy treatments is a direct effect. We are also seeing pleaded claims for inflated PSLA awards, the argument being that the effects of lockdown restrictions, self-isolation and remoteness from family and friends are enhanced in a claimant with limited life expectancy. I am not aware that the court has been asked to rule on this issue yet, but on the right case, we can see that this may have some merit, particularly where a claimant has been required to shield, which would not have been the case but for the asbestos-related condition. Certainly, we can expect to see allegations of treatment delay, a backlog due to claims not being progressed, where claimants are unable to engage digitally, and enhanced loss of earnings claims due to the inability to work, due to anxiety, or the requirement to self-isolate. Finally, I would like to touch on causation. Last year's decision in the case of Bannister gave some hope to defendants following the court's approach to the concept of de minimis exposure. The circumstances of the claimant's alleged exposure were unusual, and in fact the court was not persuaded that there had been any exposure at all. However, the judge accepted epidemiological and medical evidence on what constitutes a material increase in risk for the purposes of the Fairchild principles of causation. The judgment provides useful guidance on assessing causation in low exposure claims. The Asbestos subject matter group comprises asbestos specialists from each office and jurisdiction across the firm who meet on a regular basis to discuss relevant and anticipated issues related to asbestos litigation. We believe collaboration between the subject matter groups is essential if BLM and our clients are to remain at the forefront of test litigation and policy decisions which map out the ever-evolving landscape of asbestos litigation. Please do contact me if you'd like to find out more about BLM's asbestos subject matter group, or if you'd like to discuss anything raised in this update.